We are live.
My name is Abina Johnson, and this is Focus on Liberia. Hit it! From Cape Mount to Cape Palmer, Mount Nimba to Atlantic Ocean, Obomi Hills to Pokondre, to educate, elevate, and promote. Talk about home affairs, hey, in diaspora, current affairs, hey, reliable information, history, talking about culture, hey, politics, education, entertainment, business, sports, advertisement, articulation. Focus on Liberia. Focus on Liberia. Focus on Liberia. From Monday to Sunday.
Hello, ladies and gentlemen, and welcome to Focus on Liberia. This is a special edition of Focus on Liberia. We are focusing on the immigration issue here in the United States. That's a ICE operation in the United States. My guest is Patricia Minikon. She's an immigration lawyer, and we're going to be talking about the ICE operations in the United States, the current operations, and also it has something to do with the visa suspension for Liberia coming to the United States. Visa suspension. There has been some issues about that. We're going to talk about that too. Let me welcome Patricia to Focus on Liberia. This is your second time. Welcome. I'm glad to have you again.
Yes. Hi, Dennis. Always a pleasure to be here. And thank you.
Thank you. And she's at Minikon Law, LLC. Patricia, before we start, let's talk about your background and with Minikon Law and also your connection to Liberia. I want to bring this up because current generation, before the show, as I was saying, they don't, we always try to connect and see who we are, and so that they'll know as we pass the baton. Let's get into that a little bit.
Okay. So I am Patricia Minikon, as you said, and I have been practicing immigration law for about 32 years now. My entire focus, all of my legal career has been on immigration law. So I've practiced through several administrations. When I first graduated, President Clinton was recently elected. So that's how long it's been. As far as my ties to Liberia, I'm a daughter of Liberia. My father's family, the Minikons, come from Grand Cess, which is in Grand Crew County, and my mother's family is, well, before I even get there, that's my dad's father's family, and then my dad's mother's family are Jacksons. On my mother's side, my mother's maternal family are the Harrises. They're from Upper Buchanan, and my dad's father was from Lofa, George Jala Cooper. So there you go. I'm all mixed up in the various counties, various places, and then mixed up in there some migrations from the Caribbean and from the freed slaves from the US. So
Thank you. That what makes you Liberian.
that's exactly why, because I am your typical Liberian with roots, that spread far and wide and all over the country,
Yeah.
including in the diaspora as well.
All right. Thank you again. I want to thank you for joining us. There's a lot of ICE operations in Liberia. And so when we have such situation, I always want to invite someone who is who knows a little more in that area to talk to us. So first of all, let's begin. If I were to ask you, I'm in Liberia asking you, I said, Patricia, what's going on in America? What will you tell me?
And I've had to answer that question too.
Yeah,
So, what I would explain is that right now, under the current administration, the government has prioritized the removal of non US citizens in the US who either do not have any status or were ordered to leave the United States, either by an immigration judge or by Border Patrol at the border. And people who are here without status includes persons who came with a visa and then overstayed, as well as persons who either entered the US without a visa or may have entered using someone else's credentials, like a passport, because there is no valid entry for the individual who assumed someone else's identity.
Mm. So basically, this is about people who has immigration issues.
Yes and no. You
Hmm.
don't have to currently be in an immigration process
Okay.
to be on ICE's list. You also may have just had a criminal conviction for a theft related crime, for example, and you could be picked up, you could be detained. So there are many categories of people who are falling into ISIS net from arrests because either they have certain qualifying convictions or
Mhm.
they have an outstanding removal order, or they have applied for some benefit that has been denied, and then USCIS refers them to the immigration court, and ICE is notified, that they're now in proceedings and without status. So, and then you have people who've had a removal order for years. They may have forgotten about it themselves. But there you go. They can also, come into ISIS net. Another way that a person could be picked up is that, like I said, they're here because they either entered without proper status or remained without the proper authorization. And they could be at a Home Depot and ICE could pick them up. ICE could raid their workplace, so there's so many ways. And a person who does not have valid status can't say, well, I'm not a target, because I think that's one of the misconceptions that we as Liberians sometimes have, is that, oh, this is about picking up, say, people from Latin America, or, other non-English speakers who are more easily identified as foreign born. But that's not what it is. It's not only limited to that either.
So what is ICE? Let's go back to that. We all
Sure.
hear what is ICE and what, how they came to, what are they trying to enforce here? What powers do they have?
All right. So ICE, the simplest way I explain ICE to my clients is that they're the immigration police. But to get more technical about it, they are immigration and customs enforcement. And they're part of the Department of Homeland Security, which is the successor government agency after the Immigration and Naturalization Service was abolished. Department of Homeland Security includes a lot of agencies, including alcohol, tobacco, firearms, the DEA, Drug Enforcement Agency. So ICE is one component, and the ICE office itself, or the ICE component, has three or four main categories or departments to them, I should say. There's detention and removal operations. They are usually the people who go out and arrest and then put people in detention facilities. There's Office of the Principal Legal Advisor, which are the attorneys for the government when someone's in removal proceedings. These are the attorneys who represent the government, and their job is to convince the immigration judge that this person deserves to be removed from the U.S. And then you have Homeland Security Investigations, which is the branch that investigates fraud, investigates trafficking, investigates other crimes that I would say are immigration crimes, but they're also crimes under the criminal code, either the federal criminal code or the federal criminal code. So,
and what is the link? This crime is not an immigration crime. How does that link with ICE?
Okay, so because ICE is the immigration police, their task is to police violations of the immigration laws. Right. So even though immigration is considered a civil offense, even though there are instances like someone who comes back a second time now commits a federal criminal offense, but most of the times immigration violations are civil. And ICE is tasked with policing that those violations, meaning if ICE becomes aware that someone is here without the proper authorization, then they can arrest them. If ICE becomes aware that someone is subject to an immigration removal order, ICE can also arrest them. Or if ICE just becomes aware, say you're visiting a friend and there's an ICE raid at, in the area, and you are picked up, and ICE discovers that, it's been a week since your visitor visa expired or your student visa expired, right. ICE can then take you into custody to effectuate your removal. When an immigration judge orders someone removed, ICE is the one tasked with getting that person out of the United States.
So if I committed a non-immigration related crime, mm-hmm. ICE will not arrest me, except that I have something, my papers, or I overstayed my visa. So people who commit these crimes, regular people who have, they're in good standing when it comes to their immigration, their immigration status, you don't have to worry.
No, actually. So the immigration laws state that a person is deportable if they commit a certain crime. In addition, the current administration, or under the current administration, passed a law saying that persons who are accused or convicted of certain crimes will be mandatorily detained. Prior immigration law also stated that persons who are convicted of certain crimes, usually drug-related crimes and convictions, will be mandatorily detained while they go through their immigration proceedings. So if someone commits a crime, if it qualifies for the mandatory detention, ICE removal and detention operations will become involved in their case, and usually will visit the detained person while they're still detained to ascertain whether that person, may be a U.S. citizen through their parents or has another claim to remaining in the U.S.
What changed, right? Because immigration, ICE has not been operating like this. What
Yes.
is this major policy shift that
The
is getting
ma-
ICE to do what ICE is doing today?
yeah, so the major policy shift has a few roots. Immigration enforcement is historically an executive branch function. And the Trump administration has issued policy priorities when it comes to immigration. President Trump campaigned on this as far as enforcing the immigration laws of the US once he became president or if he were elected president. So, immigration enforcement is a priority of the administration right now. And Congress has passed the Laken Riley Act, which talks about persons who have been accused of crimes, not necessarily convicted, but simply accused of crimes, who would face mandatory detention. Also, Congress has passed a recent bill that funded ICE at unprecedented levels. So right now you have the combination of the policy shift and the funding to do it. Yeah. So the major policy shift, I would say, is that ICE or the immigration agencies are no longer in the business of keeping families united. So before the Trump administration, you could apply for what is called prosecutorial discretion, even if someone were in removal proceedings, and based on their ties to the U.S., family members, their cases could be closed or even dismissed. What the Trump administration is doing is reopening some of these cases to put the person back in removal proceedings, despite their very close ties. These are like the children of U.S. citizens, spouses of U.S. citizens, parents of U.S. citizens. So they're placing them back in removal proceedings. So that is a policy shift. Also, USCIS before, like say, for example, your spouse filed for you and for some reason they denied it. Say maybe they weren't satisfied with the affidavit of support, or you didn't respond to a request for some document, they would just deny it and close the case, giving you an opportunity to reapply. Now, if USCIS denies an application, they place you in removal proceedings. So yeah.
Well, thank you. I like that. But what is mandatory detention? What does that mean?
Yeah, mandatory detention means the person does not qualify for bond and they have to remain detained until the immigration judge reaches a decision in their case.
Good. So, what is the, from your perspective, what are the biggest misconceptions immigrants have about ICE and immigration enforcement?
Yeah, so ICE recently claimed that they can break a door down, but and I say that before I even begin on the misconception. A warrant, an arrest warrant from ICE is just that, an arrest warrant of the person, because it's not a warrant signed by what they call an Article 3 judge, meaning a federal judge, either at the federal district court, federal appeals court, but usually federal district court. Because it is not a warrant signed by a judge, it does not allow the ICE agents to enter a home, because the Fourth Amendment guarantees the right against search and seizure without a warrant. Those are that is a founding principle of the country, the U.S. that is. So That's something that people don't realize, that if ICE has a warrant and knocks on their door and the door is locked, they do not have to open it. And even I know ICE is claiming they can break doors down, but I would say
Right.
that allow them to break the door down, because a warrantless search can be challenged before the immigration judge, and the evidence seized can be excluded. Now, it's a little different for someone who has a removal order, because once the door is broken down, you will probably be detained and put on a plane shortly thereafter. But if you open the door, then you are inviting ICE in.
Hmm. Yeah, even before I get to that, Ms. So that leads me to what ICE can or cannot do. So in that case, if ICE breaks your door down, what do you do? And do they? So let's talk about what ICE can do and they cannot
Yeah.
do legally,
As
and
far as
what would be the redress?
as far as I'm aware, under the laws of the United States, ICE does not have the right to break your door down, but ICE says they do. So that means they might intend to, because I learned that in Minnesota earlier this month, that was just what happened. A Liberian who had received a deportation order back in 2023 was forcibly taken from his home. So, you know, what happens if you already have a removal order and ICE does forcibly take you from your home? ICE will be then getting ready to enforce that removal order by putting you on a plane.
Mm.
If you are simply here as an overstay and you've been here longer than 2 years, you will more than likely be placed in removal proceedings. In your removal proceedings, you can then challenge the any evidence that was seized. So, say for example, ICE breaks your door down and they seize your Liberian passport and are relying on that passport to prove that you are not a U.S. citizen and you don't have authorization to stay here. You can challenge the basis for that citizenship determination because the passport was obtained without a search warrant and without your permission for ICE to enter your home.
So can you sue ICE, or what happens if they don't have to do this, but they did it anyway? What
Yeah.
is the legal recourse?
Well, that's not really my area. I am an immigration specialist, so I focus on immigration, and such a lawsuit would be in federal suit. It's a suit against the government, and there are certain preconditions that allow someone to sue the government. If they feel their constitutional rights were violated, then yes, they can sue. Um, and like I said, they can use the violation to help them in immigration court, because if ICE cannot prove that the person is not a US citizen and they lack, the judge excludes the evidence of the passport, then it's difficult for ICE to prove their case. Because when a person is placed in removal proceedings, there are certain allegations charged against them, that they're not a US citizen, they're a citizen of X country, and they entered the US either without authorization or with a visa that was given to them for a certain amount of time, and they've now overstayed. So ICE has to either prove the allegations or the person has to admit to them. So if there's no admission, then ICE has to prove it.
Right. So now, like for those who are here legally, let's say you're even a citizen, but
Yes.
can ICE go back, or the government go back and investigate? Well, even though you're now a citizen, but you did not become you became a
Yeah.
citizen by maybe lying or by doing
Yes.
something that is you shouldn't have done. Can they go back to reverse that and deport you?
They sure can. And that's one of the Trump administration's priorities, apparently. President Trump wants to denaturalize 200 naturalized citizens every, I believe it's every month. So what happens is that right now, ICE is not ICE, I'm sorry. USCIS, which is the benefits branch, um, they are going through applications that they have approved, because USCIS is the branch that approves naturalization application. They're going through different applications they've approved and screening to see if whether there were any irregularities. Now, understand that denaturalization has always taken place, and the law does provide for that. However, there has historically been denaturalizations of person who lie on their naturalization application or did not obtain their U.S. citizenship properly. So examples could be someone has a criminal or a criminal record. They're maybe going through the criminal process while they're going through their naturalization process, and they don't disclose that they've been arrested. They haven't been convicted, but they have been arrested. And the form requires you to disclose if you've been arrested. And they don't disclose it for some reason. It's not picked up. And they become a naturalized citizen. Well, if they eventually get convicted and that comes to the attention of the government, then yes, they will take their naturalization away because they didn't properly obtain it. Someone who improperly obtained their asylum, which later led to their green card and then led to citizenship, if they didn't receive that asylum properly, say they misrepresented information, or they didn't qualify for asylum because they had been a human rights abuser, but they didn't disclose that on the application, they can have their citizenship taken away.
And these things have always happened.
They've always happened, but there was never a quota saying there has to be 200 every month. The problem with quotas is that it provides the wrong motivation for people to try to meet the quota. So you may have a situation where persons are being denaturalized for suspected irregularities when they aren't irregularities at all, but the employee doing that review is incentivized by the fact that they need, their office may need to find 40 applicants to denaturalize that month. So that's the part of this that, makes it troubling, very troubling, that now there are quotas on denaturalization. It's not an organic focus. It's not an organic process anymore.
Ladies and gentlemen, if you're just joining us, this is Focus on Liberia. My guest, Patricia Minikon, is an immigration lawyer, and we are discussing the current ICE operations and the Liberia visa suspension, which we're going to get into in a minute. But let me ask you on so what are we supposed to do?
Yes.
Even going out, whenever you are approached, whenever you are arrested, what are we supposed to do?
Well, only permanent residents are required to carry proof of status. That's always been the case. It has not been enforced as aggressively as people need to do it now because of the risks they face of being detained by ICE if they can't prove their status. And even some people who do say, I'm a permanent resident, they still get detained. And then, maybe their family members have to take the actual document if they don't have it. What I suggest people who ask me now and who are concerned at being detained is you can make a photocopy of your card if you don't like to carry your originals. You can take a photo of it to have on your phone, or a photocopy you can put in your wallet or purse. If you're a U.S. citizen and you have a passport card, you can certainly carry that card in your wallet or your purse like you do a credit card or your driver's license. Understand, though, that, again, ICE can take someone in until they verify that these documents are correct and that their, computer records show that it's a valid green card or a valid citizenship card. And if someone is being picked up, perhaps for pursuant to denaturalization proceedings, they could be detained and then would have to apply for bond before they could be released. So even though you're carrying those documents, it's just a first step at avoiding being detained indiscriminately.
Because they can still take you and you have to prove that later.
Correct. They can take you back to their offices to verify in the computer that you are a permanent resident, that you are a U.S. citizen. Because there are times, if the person doesn't have any proof, well, then, especially if they're a permanent resident, they're supposed to carry proof. The law says it. And they're supposed to change their address whenever they move. So if you just have the proof, if it's paper, the agent doesn't have to believe it's valid if it's not the original card. And even then, they still have the discretion to take you back and verify it.
Okay.
Yeah.
Here's a question from our viewer, Anthony Rogers. What about a person came for a visit in the U.S. and never went back? In other words, you overstayed your visa and you became a citizen. Can you be denaturalized?
Well, they cannot be denaturalized just because they came and overstayed their visa. They would have to be denaturalized for a certain reason. Now, that said, if they got a green card in a category that required them to still be in valid status at the time they were granted that green card, but say they were granted the green card by mistake, then they didn't get the green card properly. And yes, they can be denaturalized because the improperly granted green card formed the basis for their eligibility to naturalize.
So when I've never had the experience, right? But what are the questions that ICE will ask you when they meet you? What are they looking for?
Well, they're going to ask your name. If they're trying to confirm you are the person they're looking for, they'll ask for your name. They very well can ask for your immigration status or your citizenship. Now, you don't have to answer, but not answering in this climate probably means they're going to detain you and take you down to detention. But you do not have to answer.
And how long are they supposed to keep you before releasing you if they find out?
If they find out that you have proper status?
Yes.
You're supposed to be released immediately. Because they don't have the authority to detain someone who is properly in the United States in lawful status.
But what is the time frame on that? Say you can keep them for, can they keep you for 3 days, 4 days, 1 day?
So here's the thing. Immigration is not criminal law. Under the criminal laws, people can't be held for more than a certain amount of time. Because immigration law is not criminal law, ICE doesn't have like a timeline. But if someone who is a U.S. citizen or permanent resident is detained, I would hope that their family would try to get an immigration lawyer involved so that, ICE can be contacted with the proof of lawful status and then, held accountable for releasing that person immediately upon receiving the proof of such lawful status.
So by the time ICE approaches you, they already have something on you. It's not random. They're not looking at you and say, this person looks like,
Well, no, that's not the case. ICE can profile, and they have been profiling people walking out of Home Depot, standing in the parking lot of Home Depot. They have profiled them because they feel they don't look American, which, a lot of times isn't necessarily true because America is a melting pot. There are people from everywhere in the world here who are citizens, who are permanent residents. So, yes, ICE can profile, and they do profile. They can profile you because you speak with an accent. They can profile you because of the color of your skin. I mean, there's so many ways they can profile you. So no, it's not only someone who has, um, a warrant for their arrest. ICE has been going into immigrant populated areas and just making arrests, mass arrests there. They've gone to employers that they know traditionally hire a lot of immigrants. So at one point, they raided the Purdue chicken factory on the east in Eastern Maryland. Um, so and they don't have to know that, or they don't have to have a warrant. They have been indiscriminately targeting people, and that's a huge difference from before. We're now living in what feels like an immigration police state.
Yeah. And is there statistics of who these things affect most? I don't know if people from European,
Mm.
you know, background, they are facing the same thing too.
Well, let me put it this way. I can I don't have access to any official stats from ICE, but I will say this: the clients who are being picked up in my practice experience and the experience of others that I speak with are Black and brown people, predominantly. Now, a lot of times for Europeans who are in the US, um, a lot of them either come with a valid visa or they come with the visa waiver and they leave, or some of them stay. That's not to say there aren't people of European descent or citizenship that are, here illegally, but the focus does not seem to be directed at those people.
Mm. All right, let's turn to Liberia. Sometimes we see the list of countries
Yes,
coming and say, visa ban and visa this and all these different things.
yes,
Yeah, let's talk about that a little. And Liberia appear to be on the list. What is the
correct.
criteria? What is it that they're looking for?
Okay. So there have been 3 travel bans. The first 2, one was in June of 25, the other December of 25, and now the most recent one in January of 26. The previous 2 did not affect Liberians, so it wasn't on, I guess, the community's radar.
Mhm.
However, this last one does affect Liberians, and it concerns immigrant visas. Now, excuse me, it's winter. I'm dealing with a
Yeah.
cold. Um, this last travel ban affects Liberians' ability to obtain immigrant visas. Now, I'm going to pause there and detour a little bit and then come back to it to
Mhm.
put it in context. The the U.S. government recently um, promulgated visa policy for Liberians, where they now get 3 years visitor visas.
Right.
However, that is a good development because it cuts down on how often a person has to go and get a visa at the embassy, at the US embassy. However, whenever you enter the US on a visitor visa, you're limited to a maximum of 6 months. It does not matter that your visa is for 3 years. You still have to leave after 6 months, or you have to apply to extend your visa to a maximum of a year if you can prove that something unexpected happened after you entered. So, for immigrant visas, the process is that people need to get an affidavit of support. What that affidavit of support says is that if the person becomes a permanent resident, before they can access any means tested benefits, meaning benefits that considers your income, the sponsor who signed the affidavit of support will be the one to cover that expenses. So, for example, someone comes in making only or they lose their job after they become a permanent resident within the first 5 years, because it only applies in the first 5 years. And the person who signs the affidavit of support, their obligation ends after that person works for 10 years and after the person becomes a U.S. citizen or passes. So every immigrant has an affidavit of support, especially if they're coming on a family-based petition. That means that this latest policy, which states that the ban is because of the high use of public benefits by these immigrants, it's a little confusing, because the reality is that an immigrant who comes here is already required not to use public benefits. And if they do, they will use their sponsor's income to determine if they qualify. And most people may be aware that you don't qualify for these public benefits unless you make a very low income.
Yeah.
So if you lose your job, your sponsor is required to make 150% of the poverty guidelines. So technically, if they turn to your sponsor's income, you should not qualify for a benefit that requires you to meet the poverty guideline, because your sponsor is 150% over that guideline. So that's why it's a bit tricky and or confusing, and I feel maybe not quite based in what the reality of the law, policy, and procedures are right now. And there might be lawsuits and challenges to it early days, but there could be, because the stated objective for keeping families separated and preventing people from immigrating, including people who are coming here on employer-based visas, who are not required to have an affidavit of support because they're coming to a job. There might be lawsuits, because the stated objective of decreasing public benefits usage does not merge with the current practice that these people already come with a limit on their ability to access public benefits.
Yeah.
Now, the State Department will continue interviewing people, but will not issue visas. So there are interviews being scheduled for countries that are facing this ban, and that is getting very confusing for people. But there are interviews being scheduled for their immigrant visas. However, the State Department, while this pause or the halt to the issuance of these visas is on, the State Department will not issue the actual visas. They'll interview you and then, I guess, sit on it.
Confusing.
Yes. Yeah. Yeah.
So our embassy tried to explain that, oh no, this is, it's not this, is the other one, right? But the immigrant visa, what is not is on hold now. That's the most important one, because that's the one that is bringing people. I mean, we don't.
Yeah, it's the one that will come with immigrant visas and they become permanent residents.
Right. So actually, to say, well, people can still come on visiting visa.
They can. They still can if they meet the criteria, because Liberia isn't on the list of countries whose nationals are required to post a travel bond or visa bond. But there are many countries that, yeah, they can come on with a non-immigrant, visitor visa, for example, but the persons traveling have to post a bond, and the bond goes up to $15,000. So that signals, even though, like I said, only certain countries are on it, but the countries are being updated every day or every week or periodically. And this means that it signals a policy shift to Department of State consular officers interviewing applicants, that they better make sure this is someone who will not use public benefits when they get here. who will not overstay. That has historically always been, the screening that they've used,
Yeah.
or the criteria they've used. But I think Liberians might be fooled into thinking that because they can now get a 3-year visa instead of some of the 1 month, 2 month, 3 month visas that were issued in the past, that if they, apply, that they'll just be given a 3-year visa. No, you still have to meet the criteria, and that criteria is being enforced quite strictly now.
Let's talk about others, right? I think that the ban or restriction that affect Liberians, like I think the DV.
Yeah, because that's an immigrant visa. So
Right.
any visa that you would enter the US and have a green card following your entry is restricted right now. So this means if your child files for you, your spouse files for you, your parent files for you, it's all on hold. Your brother or sister files for you, it's on hold. And this can mean the family member can be a permanent resident or a U.S. citizen. It's not clear, but I suspect fiancés will be caught up in this as well.
Yeah.
A fiancé visa is a non-immigrant visa, but it allows you to have immigrant intentions. So at the end of the day, you are required to get married within 90 days and then file for your green card. So, and the processing for a fiancé visa is similar to that for an immigrant visa, in that the person, the fiancé abroad, has to get a medical exam. So even though a fiancé visa isn't a non-immigrant visa, that visa category is more than likely going to be affected.
And this question for our viewers: do Liberians actually understand this? Do we really understand? Because just a few months ago, we were rejoicing that we're not on the list, that we got this 3-year visa. Now, with this hold on immigrant visa, I wonder if Liberians really understand what's happening and what that means. That's rhetorical. So if you're watching, I want to get your view on this. Now,
yes,
let's read a few comments here. Sam Shepard said the man said it loud and clear. He doesn't want garbage people. In simple terms, people of African descent coming to the U.S. Instead, he prefers people from Europe. Tia Emmanuel, if you overstay and you are deported and are given a specific time not to come to America, but NTR, I don't know if that understand.
Yeah, not to return. Okay, let's take it one at a time. When you are deported, if say you're stopped at the airport or at the border and you are what they call placed in expedited removal proceedings, usually you have to stay out for 5 years. If an immigration judge orders you removed, you have to stay out for 10 years. If you are removed due to a criminal conviction that is determined to be an aggravated felony, it's an immigration aggravated felony, you cannot come back for 20 years. And if you do come back, you're subject to immediate removal because of the order that you left with. And if you come back a second time, you can be charged with the federal crime of re-entry. And that carries a jail term of about 20 years as well. So you'll be a guest of the federal penitentiary system for 20 years if that happens.
What if you self-deport?
If what?
If you self-deport, like
yes, if you self-deport, and let me tell you what that means. There are two ways to self-deport. One way is you came in, you overstayed your visa, no one's caught up with you yet, but you don't want to live in this climate and you decide to return to your home country. That what will happen if you try to immigrate, you'll have to stay out for 10 years or file for a waiver if you have a relative who is either a parent or a spouse who would face extreme hardship if you weren't allowed to return within 10 years. Now, if you overstay a visa, the embassy will see that when you go to apply, because the questions on the application for the non-immigrant visa asks for all previous trips. And once they discover you overstayed, chances are they're not giving you another visa. So effectively, you're banned, because to get an immigrant visa, you have to either apply and be granted a waiver, or you have to stay out for 10 years. And you probably will not receive another non-immigrant visa. So that's if you just leave, there's no pending order of removal. If there is an order of removal, maybe entered against you in 2022, and you didn't leave, and but now with this climate, you decide, you know what, I'm leaving. Get my one-way ticket to Monrovia, and you leave. That removal, you've just effectuated that removal order, much like ICE would have put you on the plane. You leaving is similar. It has a similar legal effect. So when you get on that plane and leave, you just effectuated your removal order, and you have to stay out for the 10 years as well.
Except that, instead of you paying your own way for me, I'll wait for us so they can buy my ticket.
Yeah. Not only that, but as a side, the government is paying people to leave. They're giving them money to leave, and that's on the USCIS website. They're also including it now in your court hearing notice, that you can leave and you can contact this number. But the difference with someone who leaves without a removal order and someone who leaves, after being ordered removed, is that for the person who leaves after being ordered removed, or whether ICE puts them on the plane, they will have to stay out for 10 years, or they will need to file for a waiver of that removability. So now they have two things they need to get waived: the fact that they overstayed without status for a year or more in the US, or 6 months or more, and then the fact that they now have a removal order. So there are some legal differences.
Thank you. Ladies and gentlemen, if you just joined us and want to participate, please call 605-313-6004. The code is 791-403-PALM. And we have our immigration lawyer, Patricia Minikon of the Minikon Law, who's going to answer. And if you have just a comment, even if not a question, I want to hear your experience too. And there are some Liberians we've seen, on the social media. People talking back and forth about ICE operations and how people are going to call other people and all these different things. So, or people that are in support of what is happening. So if you're watching and want to share your experience, you can also please call the number 605-313-6004. The code is 791-403-POUND. We encourage our friends and people watching us from Minnesota, please all call and share with us how is it like.
Okay, now you mentioned something about people who are in support would be calling ICE on other people. Is that what you're talking about?
Yeah, there are people who are saying those kind of things.
That they will do that? Well, yes. That's been going on forever. Since Liberians have been here, people have done that. Love triangles sometimes lead one party in the triangle to call immigration on, their rival. And yeah, ICE is welcoming that kind of information. But what I would suggest to people is to be careful, because the trap you lay for someone can catch you, in the sense that if you call immigration on someone, maybe the person who you've called the immigration authorities on knows something negative about you or somebody you care about, and they can take you all down. So you can burn down the house, or you cannot. So something I did want to point out to people, USCIS has changed how they will use information provided by third parties. So, for example, if someone files a Violence Against Women's Act petition because their spouse is abusing them,
Yeah.
USCIS, I'm sorry?
No, it's good you mentioned that. I wanted to come to that. So thank you.
Yes. If their spouse is abusing them and they file, USCIS now will actually consider any letter the spouse files saying, any negative things. And the common scenario is this: two people get married, things aren't going well. One party gets mad and writes immigration to say that this person only married them for their green card, or makes accusation that the person's involved in violations of the immigration laws, violation of the criminal laws, and thereby that person now goes to their interview, for example, maybe their naturalization interview, because a lot of times these things happen after the person gets their green card and splits up from the ex-spouse. They will use this derogatory information against the applicant, notably in an effort to say that the person committed fraud or misrepresentation in applying for immigration benefits, because that's another priority of the administration, where they're focusing on reviewing applications for fraud, reopening asylum applications to review for fraud and misrepresentation. Fraud is where you actually submit a document that's not correct, like you put the wrong parent's name on the birth certificate. And misrepresentation is where you maybe go to your interview, get a student visa, and then say you're going to be attending classes starting, whichever date, but then come and never attend classes. So those are things they're looking at. And for a long time now, USCIS, when you file for a benefit, a green card, whatever, they have access to the Department of State's records. So that application you filled, your answers to questions, they have access to it now. And they can use it to prove you've been inconsistent before, the embassy, and then before USCIS, which is where the misrepresentation charge comes in. And let me just add, I'm bringing this up, and by the silence, I think I'm freaking people out, and people are like, oh my gosh, what's coming down the pike? But people need to know this. They need to know this. They need to be educated on this, because, like I tell my clients, we plan to win in the office, not in the courtroom. So with proper planning, you can be prepared. You can have a strategy, defense strategy, if this comes up. Do we have any audience questions, or can I talk about a few?
Sorry, sorry. I have a caller on the line. I didn't know I was muted.
Oh,
Sorry.
okay.
Yeah. Okay. Nelson is calling from Minnesota. Go ahead, Nelson. You're live.
Yes, I just want to ask you. I think for her SOB, she explained so well, and I really enjoyed the topic. I just wanted to ask the question because I have a family friend who her interview is due on the 4th of March, and then our document presentations will be on the 3rd. So in that case, what happens is visa will not be issued.
That is correct.
In outside the country, the interview is outside America.
Yeah, at the embassy.
Okay.
So the way the embassy works, you have one interview like the day before, so they can go over your documents just to make sure you have all the required documents, and so the actual interview can go a little smoother and faster. And then the next day you go for your actual interview where you ask questions. So yes, they will keep, the embassy will keep the interview date, they'll keep the appointment, they'll do the interview. They haven't said whether they'll still collect the passport as they do at the end of the interview and then just hold on to it. But the thing is, because people don't know how long this pause is for, if you have another opportunity to go to another country, then your passport's stuck in the U.S. Embassy and you don't know when to return it. So, yeah, they are conducting the interviews. Now, whether they'll re-interview people later, I'm not sure. Just because if this keeps up until the Trump administration ends in 2028, then by then passports may have expired, various factors. Affidavit of supports might need to be refreshed with current tax returns. So it's uncertain right now whether they'll keep the passports or not.
And for those who say you're in Liberia, you have your visa already, can they allow you to come?
Yeah, if the visa was issued before the date of the pause, then yes. I mean, and no one got a visa after the pause. So if you've already been issued your visa, yes, they can proceed.
Thank you. Nelson? Go ahead, Nelson.
So the public should proceed with the process, right, and do all the necessary.
Absolutely. Yes, they need to go through all of the steps. And something that's critically important, if they change their email address, if they change their phone number, they need to update the embassy, because a lot of times abroad, the only way the embassy has to notify someone is by email or a phone call. And if you don't keep those means of communications updated, when they are ready to act, are ready to issue this visa finally, they might not be able to communicate with you. And if you fail to communicate with the embassy for a year, they will revoke that visa. So they'll cancel your case. So you will have lost all your wait time, waiting for a particular visa, et cetera, and all the fees you've paid.
Thank you. So if you know you apply, just keep data on your phone as well. Let me bring on our next caller here. Our next caller is caller, your name and where you calling from.
Hello, my name is Emmanuel. I'm calling from Minnesota.
Go ahead, Emmanuel, you're live.
Okay, thank you so much for the topic tonight. Very interesting. I'm asking this question on behalf of a friend. A friend of mine wants to go to Liberia for a visit to come back. He has a green card, but he's worried about going and thinking that maybe on his way back, they might not grant him re-entry. And his fear is, he got his green card on the basis of a waiver a few years ago. On his way back, will the waiver issue not be a problem for him for a re-entry? So he's right now. Okay, yeah.
All right. So it's difficult for me to answer your question because the challenges he will face upon return can't be determined without an individualized assessment of his situation. For example, what was the waiver for? Was it a criminal waiver? Was it a fraud and misrepresentation waiver? What was the waiver for? And what's been happening in his life since? Are there any crimes that could flag? Because when he comes back, he will more than likely be fingerprinted, or they'll look him up in the system. So what your friend wants to do is to schedule a consultation with an immigration attorney who is, I would say experienced and knowledgeable, and have them do a thorough evaluation of their travel risks. But now is not the time to just travel if you have concerns, because people usually have concerns because of a reason. They kind of know something's been, a challenge in the past.
Thank you.
Yeah, he has no issue with crimes,
Right.
according to him. So I think it's just because of the waiver. So I think it's a good idea to consult a lawyer before moving.
Yeah, understand that someone does not need a waiver unless they're not eligible to get the green card. So even though it may not be criminal, but something required him to get a waiver before he could get a green card. And that is why I mentioned him needing to have a thorough assessment, because there's things in his past that prevented him from getting a green card before. And even though he got a waiver, you never know because the laws do change.
Thank you. River Says Pro is asking the pause. Thank you, Emmanuel. River Says Pro, what is the actual reason for the pause on the visa?
Yes, the pause on the visa is that the Trump administration has stated that there is a high public benefits use rate among the countries on that list, including Liberia. What they mean is the people or the citizens of those countries come and have a baby, for example, and Medicaid has to cover the fee, or these the people who come from these countries are applying for food stamps, or are applying for aid from the federal government. Now, what this announcement doesn't take into account is the fact that someone who comes as an asylee or a refugee is allowed to use these benefits. They would still be counted as citizens of these countries, but they are allowed. They're encouraged, in fact, to use these benefits so they can prepare for a life here, training, and that they can get assistance while they're in school full time. So, it's not quite clear that the people who are coming and using public benefits actually came here as, say, family-sponsored immigrants, because family-sponsored immigrants cannot access public benefits for the first 5 years that they're here. So it is unclear that the stated reason actually plays out in reality.
Thank you. Dr. Tim Nevis, is it more difficult now under the current regime for new Liberian immigrants coming on K-1 visa to acquire work permit? And how is this work permit different from a green card?
Okay, so a K-1 visa, if it is not affected, because as I explained earlier, is a non-immigrant visa with immigrant intent, in that the fiance is expected to get married within 90 days. So if the fiance comes, they're given a visa for 2 years, and that's why it's a little different from a green card. The fiance is not the spouse of a citizen, and as such would need to become the spouse of a citizen in order to obtain that green card. And fiancés are authorized to work for the duration of their 2-year status that's given to them. So that's the difference. It's a non-immigrant visa versus a green card, which is an immigrant visa, and they can work pursuant to a work permit, whereas the green card serves as the proof of status and ability to work.
Thank you. There's a long one from Chia Tape.
Okay.
Can a person who's married and going through their process, but it's taking a long time, they already did the divorce, but only have a work permit, not a green card, but after 5+ years, get a call or a letter to apply for citizenship, completed the application, did interview and all of that, but still awaiting their swearing in. My question here is, can that happen? You do the interview without green card for a citizenship?
It is possible, but unlikely. And if it did happen, maybe the person was granted their green card. But let me just say this: immigration, USCIS never writes anyone to invite them to apply for citizenship. It might be a scam. That's something you have to consider. but USCIS never writes people to apply for citizenship. Now, the scenario, can you put it back up? Let me, the scenario, if your case through a spouse is taking a long time, chances are there's a reason, not a very positive one. So you want to check. Those are the cases where sometimes, because the spouses have divorced, the ex-spouse has contacted USCIS to say the person only married them for the green card. Also, this person only having a work permit indicates to me that they may never have gotten to the approval stage, because if you're approved, then you get a green card, not a work permit. But you get a work permit in the interim while waiting for a decision on your green card. So, yeah, I suspect there's a problem also for people who filed an application. I'm done reading the text, if you want to put it down. For people who filed an application, you know, some time ago, maybe through marriage, they've moved on. They need to order a copy of their file. Why do you want to do this? You want to know what happened. You want to know what happened. Like I said, in a lot of these cases where it's a marriage-based green card and it takes a very long time, it can be because USCIS placed the couple under surveillance and found out negative information about the validity of the marriage. Or it could be there's derogatory information sent in by an ex-spouse. But the thing with immigration is that your immigration history always matters when you file for any new benefit. So you need to know what happened.
Thank you. Someone is asking for your number. Is there a direct number to the lawyer or address to her law firm?
Yes. How the phone number to my office is 301-220-2280. If you go to miniconlaw.com, that's M as in Mary, I, N as in Nancy, IKON.com, you will find the address to the office there, and more information, of course.
All right, so that's the number. You can copy that, and or you can go to miniconlaw.com.
Yeah,
and that is MINIKON law.com. So you can do that. And a few more questions that I can read here. It looks like J. Kim Lit. He said, based on the ongoing immigration process, what exactly are the cause? What is the cause of Liberians being deported? And if you have green card with no criminal record, are you in harm zone? We started with those. Also, so let me add this one, because this is another question that we talked about earlier. The Trump administration is requesting at least 200 cases for immigration field officers for denaturalization. Is that quota possible? On what basis you think cases will be selected? We addressed that earlier. So
yeah, I don't have a problem addressing it again. The question was, the first question was, is someone with a green card, and why are Liberians being deported?
Yeah.
Liberians are being deported for several reasons. Now, some people, when they go for their naturalization, they're giving information that they engaged in fraud or misrepresentation at some point in their immigration journey. And based on that, if you don't get your green card properly, you can lose it. So based on that, they're bringing charges against them. The specifics will vary as far as why. Liberians being deported is if they have an outstanding removal order, or are here having overstayed their visas here without status. So yeah, those are common reasons or they could commit a crime that now they're a permanent resident, but they commit a crime that could cause them to lose their green card, because certain crimes will cause you to lose your green card. And the second question about denaturalization, I did cover it earlier. Whether it's possible, of course. I mean, if people want to select 200 files and place those persons in that denaturalization proceedings in federal court, then yeah, it's possible they can do it. Whether they'll prevail is another question, though, entirely, because to prevail in denaturalization proceedings, you're before a federal judge and you need to prove your case as you brought it. So if the denaturalization is, say, based on the fact that at the time the person got married, they weren't divorced, and they can prove it, then yeah, there's going to be a problem, because the marriage that gave them the green card was not a valid marriage, in that they weren't free to marry a new person. So, it's definitely possible. And I know that was a bifurcated 2-part question. So do you remember the second one, Dennis?
That's good. River says need to pay for consultation. So now, James said she got to be our former Minister of Security daughter.
Guilty as charged. Guilty as charged.
And there's one question here. Somebody who loved me so much. Let me see what they say. Say thank you, Brother Jah. Oh, I appreciate it. Yeah. We don't have any more person on the line. I know we cover a lot, but anything that you want to still touch on that I didn't ask.
Yeah, Liberians who still have DED or who have pending asylum cases, what should they do? Well, with asylum, USCIS had been, or the asylum offices had been sending out notices that people had to pay $100 yearly annual asylum fee. That's been paused, but it, depending on what the litigation results are, it might come back. So again, this is where having a current address is important, so that USCIS and the asylum office, I should say, knows how to reach you. So you can pay the fee, because it's not quite clear if you don't pay the fee, whether they, what do they do with your case? Meaning if a fee is required for an application, as you know, and you don't pay it, your application is rejected. So, people want to do that. And for persons who have DED, try to consult with an experienced immigration attorney to see if you have any other options, because, DED is in effect, but you never know how long. And then people are always, sort of nervous when it comes time for it to be renewed, just because they sort of can't plan their lives beyond the 18-month extensions. So you want to, start looking into other options. So to advise someone who overstayed their visa without status to leave by themselves or risk being deported, it depends on the situation. Right. Why are they here? Why did they overstay their status? And do they have any options for obtaining status? So that's not a question that can ever be answered in a vacuum. The person needs an individualized assessment. Has USCIS surveillance drastically increased? I would assume so, simply because, and it's Homeland Security investigations that does the surveilling, the investigation arms of ICE. Now, I would assume so because the focus right now is on fraud and misrepresentation, rooting out fraud and misrepresentation. So, of course, if there's anything that makes an officer suspicious when they review a filing, they will be investigating. People can expect to see more split interviews, where you go in with a family member and they interview you separately to see if your answers would conflict with each other. So you right now is not the time. And I know I'm an immigration lawyer, so people may think this is to be a self-serving statement, but it's not. This is not the time to be filing applications on your own, especially if you know there are things not regular in your background. This is not a time to be filing applications on your own. If you know, aren't used to dealing with a lot of paperwork and having to track things, you know, and it's just not the time to be filing on your own when the government is looking to prove that people are committing fraud and misrepresenting information to, you know, on their applications.
Well, if you want more, please visit www.miniconlaw.com or call 301-220-2280. And then
Yeah,
you
I
can
do
call.
offer Zoom, WhatsApp, or telephonic appointments. So, you know, I have clients outside of Maryland, all over the world, actually. So if that's, you know, if that's what it is. However, you know, if people know a trusted lawyer, immigration lawyer, then go to them. But you want to make sure the person you're going to knows what they're talking about, knows the law. You know, I've been doing this 32 years, so I do know the law, but that doesn't mean, you know, another attorney. It's just that you don't want to go to someone who is not as knowledgeable,
Right.
and could, you know, give you advice that comes back to be a problem for you.
Yeah, that is true. www.miniconlaw.com. The number to call 301-220-2280. And this is a second time on Focus on Liberia. So if we have some of these issues, we always want to bring the best. And I want to thank you so much for coming. If there's any other thing you want to mention before we close, please do so. And also, if you what are the next step at the end of the day? You know, everything that we've covered. What are we supposed to do now, going forward?
We're supposed to act smart. We're supposed to get a lawyer if you need one, and not focus so much on what it costs. Because a lot of times I've seen too many cases where someone comes to me too late because they were trying to do it on their own. And a lawyer can only do so much. If you have already dug the hole so deep, you know, the lawyer can try to get you out, but may not be able to because you've already gone too far. So you want to try to get some competent guidance and counsel at the very start. And like I said, when I say we want to operate smartly, meaning make sure you protect your rights. That's what lawyers are for. You know, that's what you want to do. And Mr. Unbreakable Tarpet, no, I just said I have clients all over the United States, all over the world. Actually, I bring people in from outside the US into the United States, from Africa, Europe, the Caribbean, Latin America, you know. So, no.
I mean, 32 years? You kidding me? I've been. Okay.
Now I'm telling you my age, right?
No. Kafumba, you came late.
Yes.
We are closing, but let's.
Yeah, I would like to address that because I actually wanted to and forgot. I said it, but I didn't say it this way. An administrative warrant of removal is a warrant to arrest someone that's issued by ICE. In the very beginning, I talked about the difference between an ICE warrant and a warrant signed by an Article 3 judge, say a federal court judge, or so that's what an administrative warrant is one that ICE issues and they're executing. So they didn't have to go before an impartial judge and prove that they have probable cause, that they have sufficient reason to arrest this person or to enter this person's home to search for someone who maybe is an immigration fugitive.
All right. Now you're closing. Your parting comments.
Yes. Right now, like I said, you want to be smart. You want to be safe. If you know you don't have status, Try to limit your trips. If you can, order your groceries for delivery. You know, if you start to feel you feel maybe someone's following you, because a lot of times before people are arrested, they are followed. Be aware of your surroundings. If you feel someone's following you, take steps to see whether that's true or not. You know, because if someone's following you, that means maybe they're about to arrest you. And maybe that's where you want to get in touch with an attorney so they can order your file. Because sometimes when people move, they don't realize that they got a negative decision, or the court wrote them to come to the hearing, and because they had moved, they never received the notice and they were ordered removed in their absence. So, you know, get the competent help that you need right now. Keep a low profile. Limit some of your social outings, because I get quite a few clients who end up in removal or ICE's grip because they went to visit someone else and that person had immigration issues. And once ICE gets on the scene, anyone there can be questioned. And it's been a pleasure. Your thanks is most welcome. It's been a pleasure to share my knowledge to helping to keep the community out of harm's way, out of detention, you know.
Again, we, on behalf of all of us here at Focus on Liberia, want to say thank you very much. And we're going to be reaching out to you again, because we're just 2 years in. So
I know, right?
it looks like forever. So
yeah.
Again,
and there are
thank
always
you.
new changes, new policies coming up.
Yeah.
That is good to keep track of. So
thank you. We want to also thank our viewers for watching, even those who will watch later. Always focus on Liberia, where we educate, we elevate, and promote all things Liberia. If people have my way, they will just watch Focus on Liberia and nothing else. But it's a society where we have many things. Until then, we're going to close with a song that says, "We are all Liberians." Have a good night, and God bless you.
All right.
We are Liberia. Liberia is our home. Liberia people. Liberia.